Aloha everyone and welcome. This is the House Committee on Judiciary and Hawaiian Affairs. Today is Tuesday, February 7th. Here we are at 2 p.m. meeting in conference room 325 at the State Capitol. My name is David Tarnas. I'm chair of the committee, and we have Vice Chair Representative Greg Takayama here, and other members will be here soon, but I want to welcome our Representative Kanani Souza as well. So today we've got a number of measures that we will be considering, so let's just go ahead and get started. I want to let folks know that when you're giving testimony, I would appreciate it if you would try to limit your comments to 2 minutes, and I'll ask you to wrap up once you reach that time limit. If you're on Zoom, please keep yourself muted and the video off until it's time for you to testify, and then also when your testimony is complete, then go ahead and mute yourself and turn your video off. Use the Zoom chat function if you need to talk to technical staff. Don't send me any messages on the chat function because I won't get them. So please just use the chat for technical issues. Please avoid using any trademarked or copyrighted images on your Zoom background, and of course, please everyone, use good manners and treat each other with aloha, and I appreciate it. Okay, so let's go ahead and start on our hearing today. First up, we have House Bill 1041. And first up, we have testimony and support from the Department of Law Enforcement.
Yes, sir.
Please come on up to the podium so everyone can hear you. Your mellifluous voice.
Chair Tarnas, Vice Chair Takayama, members of the committee. My name is Mike Vincent. I'm with the Department of Law Enforcement, and we are in strong support of this administrative measure. And we'll send our testimony, but I'm here to answer some questions on why this one is a little different, this task force. Thank you.
Okay, thanks. Well, please stick around because we'll ask questions about how it's different, because we've done this a number of times. Next, we have testimony and support from the Department of Transportation. Mr. Ed Sniffen. No. Please introduce yourself.
Aloha, Chair Tarnas. I am not Ed Sniffen. I'm Jory Kalili, the DOT Harbors Deputy. And we stand on our testimony in very strong support of the measure. Here for questions.
Thank you very much. Appreciate you being here in person. Next, we have written testimony and support from the County of Kauai, Councilmember Cowden. We have also testimony and support from the City and County of Honolulu Makiki Neighborhood Board, Samuel Mitchell, on Zoom. Please proceed. Nope, sorry, Mr. Mitchell is not there, so we have testimony in writing only. Next, we have testimony and support from the Pearl City Neighborhood Board, Larry Veray. And we have testimony with comments from the Hawaiian Humane Society. If you're on Zoom, please proceed.
Aloha, Chair Tarnas, Vice Chair Takayama, members of the committee, Stephanie Kendrick from the Hawaiian Humane Society. We'll stand on our testimony offering comments on this measure, but super excited to hear from the Department of Law Enforcement on how this round is going to be different in terms of the task force. Thank you for the opportunity to testify.
Thank you very much. We also have another person of the Hawaiian Humane Society, Serena Stefanik Phillip, in support. And we have written testimony and support from Animal Rights Hawaii, Kathy Gogol. And we have testimony with comments from the American Promotional Events Incorporated, Brian Tim. Welcome. Please proceed.
Hello, Chair Tarnas,
Aloha.
Vice Chair Takayama, members of the committee, Myung-oh, here on behalf of American Promotional Events. We offer and stand on our written comments to the extent we can provide value for this new task force under the Division of Law Enforcement. We'd be open to contributing and providing feedback. Thank you, Chair.
Thank you very much. Next, we have testimony and support from Alicia Maluafiti, Poi Dogs, and Popo.
Thank
Welcome.
you, Chair. The one thing I wanted to offer up, given the recent media story about the guard at the prison really flying in illegal fireworks, that just maybe, I know the task force is already large, but maybe somebody from one of the mail carriers would be helpful to have on this group, either from the post office or United Parcel, or just somebody else that would deal with some of the stuff that's flying in. Thank you.
Great, thank you very much. Appreciate your testimony and support. We have written testimony and support from another person with the Hawaiian Humane Society, Maria Lopez. Testimony with comments from Matson Navigation. Testimony with comments from Hawaii Harbor Users Group. Written testimony and support from several individuals, Valerie Weiss, Cheryl Reeser, Holly Nishimitsu, and Melanie Kim, Johnny Kelly, Michael Rice, Suzanne Eubank, Lois Crozier, Daniel Freund, Stephanie McLaughlin, Lynn Matusau, Dana Chiave, Carol Richelieu, Carrie Harrington, Natalie Hansen, Martha Shelton, Tara Murphy, Kim Shelton, Jennifer Chiwa, Victor Ramos, Troy Schacht, Beverly Heiser, and Natalie Graham Wood. Is Tara Murphy on Zoom? Nope. Okay, so all those are written testimony and support. Is there anyone else here wishing to give testimony on this measure? If not, questions, members? Vice Chair Takayama, please proceed.
Yeah, I have a question for Mr. Vinson.
Yes, sir.
As the Chairman Tarnas alluded to, we've had task force reports in 2011 and 2019.
We have.
And they both basically came to the conclusion that the way to stop fireworks coming in illegally is some kind of random inspection of our incoming shipping containers, and also considering decriminalizing fireworks violations. So I'd like to know from your perspective why this proposal would be any different.
Well, last December we were approached with this, and then New Year's came and we got the injuries, a death, and felt it was really important to look at the task force. And the difference with this one is this is criminal focused. We're not looking so much at a civil enforcement type of a situation. We like to be able to conduct investigations, make arrests, and prosecute the criminals, those people that are actually bringing these things in, distributing them, and it's a little different. So the people on the task force are primarily those involved in the criminal justice system. The director nominee is a former ATF agent, is very familiar with fireworks and the federal partners. We've already met with, I can't say all the police chiefs, but most of them, and all of them are excited about working with us on this. It's going to be, the intention is, it's a different focus. We're looking at setting up cases and doing them right so that we can have successful prosecutions, not just under state and county laws, but also under federal laws. Federal laws carry significant penalties for these display fireworks. I mean, you're looking at $250,000 fines, 10 years in prison. It's more than the C felonies that we have here. So we're looking at trying to do it a little differently and look at the people that we really want to go after and help curtail and stop. We're not going to stop, but significantly reduce the number of illegal fireworks, aerial fireworks that we have in the state. And that's why it's a little different. And we do have people working with the post office task force, and yes, we are aware of the guy.
Is it your sense that, based on what we know now, that most of the illegal aerial fireworks are coming in via shipping container? Or
They're coming in across the ocean somehow. And we would be looking at that. We know that there's been some investigations and looking into this, and I really don't want to discuss them, but different avenues are being used, and we're looking at them. They are being looked at by, we know that the county police are looking at them. We're looking at putting some of our investigators on them as well.
And you made reference to the fact that under federal law, there are severe penalties for these kinds of crimes. If that's so, why aren't the federal investigators being more active in terms of trying to stop what's coming in?
I think that's part of what we're trying to do is link up the county, state law enforcement with the federal law enforcement. And we think we've got the right mix now to actually keep those establishments or those relationships, develop them, and actually get them working together. There's a number of task forces that we have state officers participating with federal agents on, and this could be just another one. But we believe that if we have the right people working the right cases and with the right information, federal agencies are going to be interested in jumping on board with some of the
Okay.
cases.
Thank you. And Mr. Chair, if I may,
Certainly.
this is more of a comment than a question, but, you know, our next bill that we're taking up focuses a similar kind of task force specifically on the cargo that's coming in, potentially bringing in illegal fireworks. So I hate to see a duplication of effort, and I hate to see, I mean, you do require resources in both the first bill and the later proposal. And so I'd rather personally see all of our resources put into one single effort aimed at stopping the incoming cargo. But anyway, thank you. Thank you, Chair.
Thank you very much.
Thank you.
Other questions, members? I have a question, just in terms of, I share the Vice Chair's concern that, you know, another task force is another task force, it's more talking. We'd like to see some action, and so the second bill we're be considering is action step. Do you really need a task force in order to do the work that you know needs to be done?
It's a matter of helping to get those relationships together and also the funding. So we support the next bill coming up, 809. We think it's going to be a great addition. We're also asking for consideration of an amendment to actually require a notice requirement so that we can actually.
Well, let's talk about that when
That'll
we
be
get to
later.
809, but the question is,
but
do you
it's-
really need a task force to develop these relationships?
It's the funding that's tied with it. So if you're putting people on overtime, bringing people on, and they've got to expend money and additional resources, that helps the agencies incentivize them to want to go after these things. So that's part of, both bills have a money component, but the task force in the next bill, we actually envision kind of being the same thing and working together.
Yeah.
It's going to
yeah.
be the same people.
Yeah, because the task force that we've got is to plan, coordinate, and engage in operations. You're saying you need additional funds in order to engage in those operations.
It's going to, yes.
Got it. Okay. Okay, if there's no further questions, we'll move on. Thanks very much.
Thank you.
Next, House, I wanted to mention, there's a couple other testimony. Elizabeth Ashley, written testimony with comments, and Ryan Christopher, written testimony in opposition. Okay, wanted to mention that. Okay, moving on to 809, related to fireworks. This is establishing a shipping container inspection program and appropriates funds for those programs. First up, we have Mr. Michael Vincent, Department of Law Enforcement.
Yes, sir, we stand.
Come on up close to the microphone so everyone can hear you.
Yes, sir, we'll stand on our testimony and support.
Okay, great,
Thank you.
thanks. And it's not just everyone in the room, there's people watching, and I want the public to know exactly what we're doing here. Improving transparency for everybody. Okay, Mr. Department of Transportation.
Aloha Chair and Vice Chair Drake Kalili again, Harbors Division Deputy. We support the intent of this measure, and we just want to point out, we do like the provisions in the bill that allow for the inspections of the cargo containers to occur off the pier. And I would just like to note, you know, we are investing millions of dollars to make our piers more efficient, and that's through land acquisitions, through tearing down warehouses that we no longer use, just so cargo can move more quickly off a ship and, you know, get goods onto shelves. And so we want to make sure that the inspection is designed in such a way where we're not impeding commerce, we're not preventing, you know, the goods that we need to get off the vessels that come into the harbors and get to stores or wherever they need to go. And so we're very open to having a conversation about what that looks like, but I just want to emphasize how we do appreciate this flexibility to have these inspections occur away from our harbors. Thank you.
Thank you, Deputy Director. Next, we have comments from the Attorney General on Zoom. Nope.
Good afternoon.
Oh, you're in person, that's even better.
Good
Thank you.
afternoon, Chair Tarnas and members of the committee. By way of introduction, my name is Trista Spear. I'm a Deputy Attorney General here representing Attorney General Lopez and her department today. Thank you for the opportunity for us to provide these comments. While the department's position is more fully articulated in our testimony that we submitted by way of summary, while the department does support the intention of this bill, we do have some concerns with regards to potential constitutional challenges because the substance of the bill in at least two locations appear to go slightly beyond that of the subject title, specifically relating to fireworks. At two locations in the bill, it also references explosives, specifically the term "and explosives." So therefore, the department respectfully recommends removing the phrase "and explosives" from those two locations of the bill to address this constitutional challenge. Further, the bill does contemplate this program beginning by October 1st of this year. year, and we anticipate the Department of Public Safety will require more time to get this program up and running, as well as to promulgate the required administrative rules that the bill sets forth. Thank you very much for the opportunity to give testimony, and I remain available for questions should you have any.
Great, thank you very much. Next, we have written testimony and support from Council Member Cowden with County of Kauai. Written testimony and support from Department of Prosecuting Attorney, City and County of Honolulu, Tricia Nakamatsu. Okay. Could you come up to the microphone and just say so everyone can hear? A little inconvenient, but I think people online would appreciate it.
I apologize, Chair. Tricia Nakamatsu, Deputy Prosecutor for the Honolulu Prosecuting Attorney's Office. We do stand in support.
Okay, thank you very much. Next, we have testimony and support from City and County of Honolulu, Maikiki Neighborhood Board. Not here, so next, testimony and support from Pearl City Neighborhood Board Chair. And next, testimony and support from Hawaiian Humane Society, Stephanie Kendrick. Please proceed.
Hello, Chair, Vice Chair, committee members. Stephanie Kendrick from the Hawaiian Humane Society. We'll stand on our testimony and support, and I just wanted to express my gratitude, Chair and Vice Chair, for your advocacy for taking concrete steps on this measure.
Thank you. Next, written testimony and support from another individual at Hawaiian Humane Society, Serena Stefanik Phillip. And then testimony and support from Alicia Malawafiti. Floor is yours. Please proceed.
Chair will stand on our testimony and support. Thank you.
Thank you. Everyone gets their exercise to walk up to the podium. Appreciate it. Next, we have testimony in opposition from Tina Yamaki with the Retail Merchants of Hawaii. Please refer to written testimony. And we have testimony support from Maria Lopez, Hawaiian Humane Society. Testimony, written testimony with comments from Hawaii Harbor Users Group. Testimony with comments from Young Brothers. Testimony with testimony in opposition from BIA Hawaii. And then written testimony in support from numerous individuals: Valerie Weiss, Cheryl Reeser, Melanie Kim, Johnny Kelly, Mike Rice, Susan Eubank, Daniel Freund, Stephanie McLaughlin, Lynn Matasau, Carol Richelieu, Carrie Harrington, Natalie Hansen, Jennifer Chiwa, Victor Ramos, Beverly Heiser, Natalie Graham Wood, Alexis Jameson, and Ryan Christopher. Opposes. The last one, Ryan Christopher, has testified in opposition. Is there anyone else here wishing to testify on this measure? Seeing none, questions, members? Yes, Representative Souza, please proceed.
I have a question for Mr. Vincent. Thank you.
Yes, ma'am.
I just have concerns as to the inspection methods. Can you perhaps explain just logistically how this is going to work? Who's actually doing the inspections? Kind of give us more details if you have them.
I know the concerns about stopping commerce. We're well aware of, we can't be stopping the containers coming off the boats or the ships and leaving the docks. We recognize the importance of making sure that commerce is flowing in Hawaii, because the reality is our harbor is the lifeblood of the state. But we also recognize that there are ways that we can figure out which containers we want to inspect, the ones that need to be inspected, the ones that are being investigated. And we've talked about places where we can do that off the docks. I mean, we're not going to, as soon as it comes up, we're not going to do that. We actually want to catch people. We want to get people that are involved in it. How we actually discover which containers, probably a wide variety of methods.
My question, I guess, hinges more on who is doing the inspections rather than, I guess my question is not really centered on commerce.
If the fireworks task force that DLE is contemplating is doing it, law enforcement officers will be involved. If there are inspectors, say an agriculture inspector opens a container and finds fireworks, they stop, call law enforcement. Okay, there's multiple ways we can be brought into the picture.
Okay, thank you. So it's actually going to be inspectors and not necessarily dock workers? I guess that's my,
No, it's not going
Okay.
to be the dock workers.
thank you.
Thank you. Other questions, members? Vice Chair Takayama, question?
Oh, thank you. And see, actually, this question is for Deputy Director Khalili, DOT. You made it a point of saying that the inspections, as did Mr. Vincent, should be conducted away from the harbor vicinity. When there are inspections now, like by state agriculture inspectors or U.S. Customs for foreign cargo, where are those inspections conducted?
So in Honolulu Harbor, for example, when foreign cargo lands at Piers 1 and 2, which is near the foreign trade zone, there's like a drive-through process where they'll inspect. And so that inspection process has been designed by both the agency as well as the shipping company to make sure it's pretty quick and seamless. And so I think my comments are to the point of the design, right? So if we can get cargo off the piers and on their way to their final destinations as quickly as possible, I think we're open to discussing, right, options for where that inspection takes place. I think among the industry, there's been just some discussion about having an inspector, and I don't know all the legal requirements for this to occur, but when a container is delivered to its final destination, have the inspector at that location watch maybe the offloading of the items from the container, and that way the cargo, the container is delivered to where it needs to be, and that inspection can happen as offloading is occurring, rather than open the container, which I know legally has some issues, and so I don't want to speak to that, but search the container, pack it back up, get it on a chassis, and then take it off the pier. So I think we're looking at what design works best to accomplish what collectively I think we all want, and where it's most efficient for that to take place.
So I guess what you described, and maybe this goes to Representative Souza's question, what you described is identifying suspicious containers and following not opening it up then and there, but following it to its destination, and whoever receives it witness them opening it? And
I think that could be an option, and I would defer to law enforcement to say where the pukas in that process or chain might be, and how to maybe address those gaps. But it's an option that I think addresses our concern about the efficiency of movement of cargo.
Well, thank you. If I could follow up with, I'm not sure whether prosecutors or AG's office, if I may,
Please.
would be the appropriate one to answer. But, you know, the reason I ask is because this isn't the first time this bill has been heard in similar form. And the last time was 2 years ago, and at the time, DOT raised the concern that they needed probable cause to inspect containers that are considered suspicious. So how do we get around that?
So, Vice Chair, you may note that when reading our testimony, it is general support. We didn't get too much into the specific legalities of it. We do think a lot more discussion needs to happen, not only among the city and state agencies, but also the federal as well. And so we're glad that there appears to be a lot of momentum or buy-in for those discussions to happen, and hopefully with the result of us having these random shipping container inspections.
So is the scenario described by Deputy Director Khalili a realistic one legally that we could follow?
I think it would depend partly on the buy-in from the shippers themselves. What point in the process would these inspections happen, with whose permission perhaps could be a part of the process.
Well, she said upon delivery that we witness the opening up the container.
That seems like it would be very efficient, not having to unload and then reload and then finally take it to its destination. But with regards to legalities, that is something we are also very interested in speaking with the feds about.
Okay. All right. Well, thank you. Thank you all very much. Thank you, Chair.
Thank you, Vice Chair. Representative Ganadin. Could you please move the microphone right next to you?
Does using like a bomb sniffing dog usually meet that legal burden of probable cause or reasonable suspicion when it's used in airports?
I think there's different standards when it comes to airports and FAA regulations and things of that nature. We have had discussions in the past whether bomb sniffing dogs could be integrated into a harbor, checks at the harbor. I think those discussions were not totally conclusive,
Thank you.
but it is different, is what we've been told.
Maybe we can hash it out if we have a task force. Thanks.
Thank you. Other questions, members?
Attorney General.
Oh, please, come on up.
Good afternoon. Thank you for all of the questions of the committee. I can't speak or answer all of them, but I am happy to take them back and provide more full comments and responses to the questions that you both have expressed here today. As I understand it so far, if I may, the questions are who will be doing the inspection based on this bill, where the inspection will take place, and at what point in the chain from arrival to final destination, as well as concerns versus whether or not there's probable cause to conduct a search, whether that's pursuant to a search warrant or a warrantless search, versus an inspection, because there is a difference between a search that may violate the Constitution, constitutionally protected rights for a warrantless search and seizure under the Fourth Amendment, vis-a-vis an administrative inspection and an administrative search. So I'm not proffering any testimony or opinions on that here today, but I am happy to take those questions either now or at the end of the hearing, take them back and provide you responses. Would that be helpful to the committee?
Yes.
Thank you.
Other questions, members? Seeing none, let's move on to the next measure, which is House Bill 145 relating to fireworks, a more, shall I say, draconian approach, imposing a statewide limitation on consumer fireworks except by permit for cultural events. So first up, we have testimony in support from the Hawaii State Fire Council, Chief Todd, Chair. We have testimony in support from Honolulu Fire Department Fire Chief Howe. We have testimony in support from the Honolulu Police Department on Zoom.
Yes.
Please proceed,
Good afternoon,
sir.
Chair Tarnas and committee members. I am Acting Major Brandon Yamoto of the Honolulu Police Department, District 8, out here in Kapolei. The HPD is in support of this bill and will be standing on our written testimony. Be available for any questions. Thank you.
Thank you. Next, we have testimony in support from Maui Fire Department Fire Chief Ventura. We have testimony in support from Department of Prosecuting Attorney Tricia Nakamatsu.
Chair, we'll stand on our written testimony in support.
Thank you. Next, we have testimony in support from City and County Honolulu Makiki Neighborhood Board. We have testimony in support from the Hawaiian Humane Society. Ms. Kendrick, please proceed.
Aloha, Chair, Vice Chair, members of the committee. Stephanie Kendrick with the Hawaiian Humane Society. We will stand on our testimony offering comments and asking for clarity about exactly what would constitute a cultural event. Mahalo.
Thank you. Next, written testimony in support also from Hawaiian Humane Society, Serena Stefanik Phillip. And then testimony in opposition from American Promotional Events.
Afternoon, Chair. Miongo again with American Promotional Events. We stand on a written testimony in opposition. I think what we've seen this past year and the years recently is that people are bypassing the permitting system and just finding it underground for these illegal area fireworks. So I think that is the reality that we need to kind of overcome and face. Right now, in terms of a draconian ban on consumer fireworks, is a little overboard. But you know, we've been assisting and helpful along the way wherever possible, especially along the path of what Vice Chair Takayama said, from when it arrives all the way to the final destination. So any feedback that we can provide, we're there. So we respectfully oppose this measure. Thank you.
Thank you very much. Next, we have written testimony in support from the Animal Interfaith Alliance, Marion Hussenbach. Testimony in opposition from Daniel Peart, Phantom Fireworks.
Through Chair, Mike Yosu on behalf of Phantom Fireworks. We also stand in opposition to this bill. We don't think it, we understand the need to control illegal and aerial fireworks, but we don't think that it's, necessary to have a complete ban of all fireworks, especially in important local cultural holidays like New Year's Day. We're available for any questions as well. Thanks.
Thank you. Next, testimony and support from Alicia Malawafiti, Boy Dogs and Popok.
Chair, we'll stand on our testimony and support.
Thank you very much. Next, we have received testimony and support from numerous individuals: Maria Lopez, Nicole with Hawaiian Humane Society, Nicole Schaefer, Kauai Humane Society, and numerous individuals: Valerie Weiss, Holly Nishimitsu, B.A. McClintock, Melanie Kim, Johnny Kelly, Michael Rice, Tori Kinoshita, Lynn Matosau, Stephanie McLaughlin, Carol Richelieu, Carrie Harrington, Bill Dixon, Harriet Morrison, Jennifer Chiwa, Troy Schacht, Beverly Heiser, Natalie Graham Wood, and Alexis Jameson, and testimony in opposition from Ryan Christopher. That's all the testimony we received on this measure. Is there anyone else here wishing to testify on this measure? If not, questions, members? Vice Chair Takayama, please proceed.
Sorry, yeah, thank you, Chair. Question for Prosecutor's Office. So my question is, we're proposing to enact further restrictions on the use of firecrackers, basically. How would you plan to enforce it? We already know that aerial fireworks are used rampantly, and they're all illegal. So how would you enforce this further ban?
I believe, did the fireworks infractions bill pass last year? That was one initiative that we had strongly supported, although it seems counterintuitive to lower simple possession of fireworks to infractions, which are no longer crimes. We felt that, that bill is still going through. It never passed last year. In prior years, we'd supported it, and we're supporting it again this year. But we do feel that if the standard of proof were lowered for infractions as preponderance of evidence, that we would have we would definitely have an easier time proving those cases, with perhaps less emphasis on having to collect the evidence, the aerials themselves, which tends to be a sticking problem. Of course, we would still need witnesses to come forward who are willing to testify. That's never going to change. But at least we do have a plan that we would like to try, as it's never been done before.
But it basically hinges on being able to enforce this as not a criminal act, but a violation that requires a lower standard of proof.
That's
and
what
that
we
would apply to both aerials and firecrackers?
That's what we're supporting,
okay.
Yes.
I guess my concern stems from the fact that this basically aims at those who are, by and large, those who have obtained permits for firecrackers and are using them. And this imposes restrictions on when they can burn them off. And while at the same time, we have multitudes of illegal aerial fireworks that we have no way of controlling at the present time. And yet we're restricting those who went through the right channels. I'm probably not saying that right, but we're cracking down on those who have legally obtained their firecrackers, and it just seems unjust that we impose restrictions on them while everything else is lit up in the air.
I think I understand the question or the concern. And we do think that this would just be part of a multifaceted approach, not just this in and of itself, but also making the infractions, fireworks infractions, the standard, having shipping container inspections, if those can be done in whatever form they can be done. We think that's another component. We just think that if you make more or less all fireworks illegal, that will deter a lot more people than are currently deterred.
Okay, thank you. And thank you, Chair.
Certainly. Other questions, members? Yes, Representative Souza.
I have a question for Ms. Nakamatsu. Thank you. My question is that, I feel like the bill goes from worse to worse because it went from a very defined designated, holidays from New Year's Eve, 4th of July, Chinese New Year's, to this vague, cultural purposes, right? So how would you guys define cultural purposes? I mean, that could technically be every day of the year if someone wanted to make the claim. So it feels like it would open it up to further, a wider or broader definition of the use in that sense.
Definitely a definition would help, or if the legislature opted to go with those specific enumerated holidays again, those are fairly well recognized in Hawaii, so we would support that. It would help.
Thank you.
Thank you. Any other questions, members? If not, we'll move on. Thank you very much. Next, we have House Bill 208 relating to criminal activity. Appropriates funds to the Department of Attorney General to collect data and conduct a study on how to reduce criminal activity in Waikiki. First up, we have testimony in opposition from the Attorney General's office. Welcome.
Good afternoon, Chair Tarnas, Vice Chair Takayama, and the rest of the committee members. My name is Julie Bato. I'm with the Department of the Attorney General. I'm the Administrator of the Crime Prevention Justice Assistance Division. It includes a branch that does research and statistics. And so I'm here today to provide testimony on behalf of the department. The department respectfully opposes this measure, and I wanted to read parts of the testimony to you, not the whole thing. The bill would appropriate a yet unspecified amount of general revenues for the department to collect data and conduct a study on how to reduce criminal activity in Waikiki. We believe that such a study is not needed at this time because the Honolulu Police Department and the Department of the Prosecuting Attorney, City and County of Honolulu, are currently engaged in activities to prevent and respond to crime in Waikiki. The Honolulu Police Department's District 6 community policing is very involved with the Waikiki community, implements a strategy of policing that focuses on building relationship and working closely with members of our community, promoting organizational strategies that support the systematic use of partnerships and problem-solving techniques to proactively address the immediate conditions that give rise to public safety, such as crime, social disorder, and the fear of crime. In September 2022, the Honolulu prosecutor, the Honolulu Police Department, other city agencies, the Waikiki Business Improvement District Association, and other community stakeholders established the Safe and Sound Waikiki strategy. The program is seeing results. According to a January 15, 2023 article in Honolulu Star Advertiser, the Safe and Sound Waikiki, in my testimony, identifies some of their arrests that they've made. So with the creation of the Safe and Sound Waikiki, local law enforcement has demonstrated that it is best situated to collect data and develop recommendations with stakeholders on how to reduce crime that impacts businesses, visitors, and residents that live and work in Waikiki. We respectfully ask that the committee hold this bill. Thank you.
Thank you very much, Administrator. Next, we have testimony and support from the State of Hawaii Organization of Police Officers. Testimony and support from two individuals, Derek Harlan and Cheryl Burkhart. Is there anyone else here wishing to give testimony on this measure? Yes, please, come on up.
Good afternoon, Chair, Vice Chair, members of the committee, Deputy Prosecutor Tricia Nakamatsu, appearing on behalf of the Honolulu Prosecuting Attorney's Department. We are in opposition to the bill itself, but certainly not for lack of caring about the high crime rate in Waikiki. On the contrary, as Ms. Ibato had indicated, we've actually been working for quite some time to develop relationships and to get an established program called Safe and Sound Waikiki Strategy up and running that did start, or it was implemented in September 2022, and to date, my most recent numbers are there have been over 660 arrests since that time in the Waikiki Safe and Sound District, and of those, the department sought geographical restrictions in approximately 258 cases, of which the courts have granted 66. So we feel that, and this is essentially the similar program that was done in other areas known as Weed and Seed. But we understand that each area has its own specific needs, and so we wanted to make sure that we didn't go into the program just trying to do a cookie cutter, one-size-fits-all project. So we have developed those relationships. We are working closely with the Waikiki Business Improvement District, and other local area organizations and business owners, as well as the residents. There was funding provided already by the Kosasa Foundation, and that was matched by the city. So those are the funds that are currently being used, and at this time, additional funds are not necessary, though we do appreciate the support and may call upon the legislature in the future if ever needed.
Just in case.
Thank you.
Okay, thanks very
Available for
much.
questions.
Appreciate that. Anyone else wishing to testify on this measure? If not, questions, members? Seeing none, we'll move on to the next measure. House Bill 480 relating to highway safety defines special interest vehicles as vehicles that are at least 35 years old. I guess that means I'm a special interest vehicle. Makes conforming amendments to provisions related to street rod vehicles and street rod replica vehicles. First up, we have testimony with comments from the Department of Transportation. Next, we have testimony in support from Sue Lee Loy, Hawaii County Council member. And then testimony in support with comments and significant amendments from Deanna Sacco, Finance Department, County of Hawaii. And then testimony in opposition from Kanan Francis, and testimony in support from numerous individuals: Tyler, Tommy Brown, Alan Madera, Sean Okamura, Tyson, Kenneth Pasco, Charlene Matsui, Eric Troutman, Eddie Kuba, Tyler Brown, Charles Lewis, Kenneth Pasco, Jason Sanborn, and Ryan Christopher. Is there anyone else here wishing to testify on this measure?
Chair, point of information.
If not, questions, members?
Canon Francis says oppose, but his testimony says support.
So Canon Francis is actually in support. Just click the wrong button on the testimony app. So thanks for correcting that. So we've got anyone else wishing to testify on this measure? If not, questions, members? I would note for members that the Hawaii County Department of Transportation said that they recommend the definition be clarified with input from representatives from the 4 county motor vehicle registration programs, and and then we did get specific information suggesting amendments from the Finance Department of Hawaii County. We did not hear from the other counties. So that's in your packet of testimony. If there's no questions on 480, let's move on to the next measure. And that would be House Bill 538. And 538 is relating to residential real property, authorizing planning and permitting agencies to enter privately owned residential real property under certain specified conditions to address violations of county zoning ordinances, rules, or regulations. And that specifies that if a property owner who receives a notice of violation and fails to remediate the violation within the specified time frame, they shall be fined a minimum of $1,000 per day, subject to a lien if the fines exceed $5,000, and then subject to foreclosure proceedings if the property owner does not satisfy the lien within 30 days of notice and commence remediation of the violation. On this measure, we have testimony in opposition from Lindsay Garcia, Hawaii Realtors.
Thank you. Good afternoon, Chair, Vice Chair, and members. We stand on our testimony in opposition. Thank you.
Thank you. Testimony in opposition from Rental by Owner Awareness Association, Alicia Humiston. Also testimony in opposition from Victor Ramos and John Chang. Is there anyone else here wishing to testify on this measure? If not, questions, members? I have a question for Hawaii Realtors. Please come on up. In talking to the introducer of the measure, and after reviewing testimony, the testimony is really in opposition to the idea, to this part of the bill that authorizes the agency to enter the privately owned residential real property. That was the opposition was really focused on that provision. I was curious if you could speak to the second part of the act, which is the the ability specifying the property owner who receives a notice of violation, fails to remediate it, that they are given these certain fines, and that if it exceeds a certain amount, then it is subject to foreclosure proceedings. What is your opinion about that part of the bill?
Thank you, Chair. At the moment, we don't have an official position. We do appreciate the intent of the measure, though would be very happy to work with you and with the introducer on understanding that particular portion of the measure and what our position would be. But
Okay.
we do support the intent.
Okay.
Yeah.
Okay, thank you. Any other questions, members? Seeing none, let's move on. And the next bill is HB 582, relating to sexual abuse of minors. Expands the time period by which a civil action for childhood sexual abuse may be initiated, including an otherwise time-barred action. Authorizes a court to require personnel of legal entities to undergo training on trauma-informed response. First up, we have testimony with comments from the Attorney General.
Good afternoon, Chair Thomas and committee.
Afternoon.
Deputy Attorney General Amanda Weston. We appreciate and understand the intent and purpose behind this bill, but I just wanted to share a concern. We are currently handling a number of cases from events that stemmed from the 1960s, 1970s, and 1980s. And witnesses are gone, disappeared, died, documents are gone. It makes it next to impossible to defend these cases. It also makes it very, very difficult to prosecute these cases on both sides. So, we would be happy to work with the legislature to find the best solution, but we don't believe that extending it for the time that is being asked for is the best solution at this time. Now, thank you for your time, and I'm available for questions.
Thank you. Yeah, please stick around. I think we'll have some questions. Next, we have testimony and support from the Sex Abuse Treatment Center, Executive Director Lynn Masuoka.
Good afternoon, Chair and Committee. Lynn, on behalf of the Sex Abuse Treatment Center, we stand in support of this particular bill, 582. From our standpoint, in looking at things through a victim's lens, it is very important that victims be provided with a larger opportunity to come forward and file that civil action. There is no statute of limitations on the criminal side already, but now we just want to enlarge that on the civil side. Kids often need a lot more time to process what has occurred to them. It could take years, it could take decades for that to happen. And so without this extension, they are robbed of that opportunity to seek some form of justice on behalf of themselves against those who have harmed them. So we would ask that you support HB 582. Thank you.
Thank you very much. Next, we have testimony and support from the Hawaii State Coalition Against Domestic Violence, Angelina Mercado. Next, we have testimony and support from Michael Goliuch, Stonewall Caucus of the Democratic Party of Hawaii. Are you on Zoom?
Good
Please
afternoon,
go ahead.
Michael Goliuch Jr., Chair of the Stonewall Caucus of the Democratic Party of Hawaii. While we support the intent of this bill, we actually would rather see the language that you find in House Bill 483 dealing with the same issue. The reason we're asking for that language versus what you see in 582 is that 483 actually removes the cap. Expecting somebody who's been sexually abused as a minor to come to terms with it by the time they turn 50 is unconscionable. How survivors are able to come to terms with it after their childhood has been destroyed is not a linear event, especially with dealing with the PTSD that also comes with it. We've already did a pilot project in the state of Hawaii on this. Unfortunately, that law sunset in 2020. There were none of these unforeseen circumstances. There were no problems that we weren't already expecting with removing that cap. Also, 483 allows for punitive damages, which are not covered in this bill from our reading of it. Without punitive damages, you're not going to be able to find attorneys to take on these cases to help these survivors seek justice. Unlike attorneys, I've been doing this for free for the last 23 years, testifying in support of legislation like this. This is my 30th time coming before one of these bodies asking for justice for survivors of sexual assault for minors. Also, 483 also provides restorative justice measures, which actually goes above and beyond what's found in this bill 582. If this body was to amend it, that we would be supportive of restorative justice measures and as well what else has been included in 582 to make this a stronger bill to support those survivors, to help send the message loud and clear that we are not going to allow these perpetrators to get off scot-free, and they will have to be held accountable for their measures.
Thank you.
So, thank you.
Thank you very much. Next, we have testimony and support from Chris Caulfield, Imua Alliance. Testimony and support from Catherine Robb, Child U.S. Advocacy. Testimony and support from Ryan Kusumoto, Parents and Children Together. Testimony and support from Ann Freed, American Association of University Women. Testimony and support from Renee Hamilton Campbell, YWCA. Testimony and support from Mark Gallagher. Please proceed.
Thank you, Chair Tarnas, Vice Chair Takayama, members. My name is Mark Gallagher. I'm an attorney. I primarily represent survivors of sexual abuse in civil claims. I'm generally in favor of the bill. There were a few issues that I had with some of the language in it that I raised in my objections, or in my comments rather. One of them is the change in how certificates of merit are treated. Generally in the past when we've had certificates of merit filed, they've been filed in camera, so only the judge has the ability to review it. The language in the current proposal would have the certificates filed electronically under seal. That would make the certificates available to any of the parties in the case. That would make it more difficult to get certificates and will defeat the purpose, which really is just a screening to make sure that the court can assure itself that there is reasonable basis for pursuing or letting the case proceed. The other issue that I have with the certificates is that it is the new language or the proposed language asks for a certificate for each defendant. I don't know what that means. Generally, a certificate just says there's reasonable basis to believe that the harm occurred or the acts occurred and that it would be harmful. So there really isn't a way to tailor that to say, well, this defendant and that defendant had some sort of responsibility. We're talking about a psychologist who has interviewed the person, doesn't have a factual basis for getting into what each defendant might have done. So I would suggest that that language be omitted, and with respect to the filing, that it continue to be what has been the practice under the window statutes, that it be in camera, so it's only before the judge. And I'm available for questions regarding any of the other comments that I raised. Thank you for your time.
Thank you, Mr. Gallagher. Next, we have testimony and support from Cheryl Huck on Zoom. Please proceed.
Mute. Hello. Aloha, honorable representatives. I'm in support of HB 582. Thank you for letting us talk about this because we've been talking about it for 8 years. I've testified on Zoom, written, oral. I've flown 5,000 miles for about 8 years to support these bills because I'm a 60-year-old tutu and I could not be able to have accountability of the person that abused me if this bill was for me. Luckily, in 2014, I had a lot of people in Hawaii encourage me to go and get that certificate and go to court, and I was able to find some sort of peace and financial support of my medications and my therapies and other children who needed help. I encourage you to not look at 32 years for this bill because that would be only 50-year-olds and below. And the fact is my sister was also abused. She's 58. She could not find any retribution. And if you don't let these people have some knowledge and understanding through the courts that they can't do what they want to do, then it's going to go on and it's going to be quiet and we're never going to have reform. So mahalo for listening to me. I am a sexual abuse trauma survivor and in Hawaii, and please eliminate the SOL.
Thank you very much. Next, we have testimony support from Carolyn Delso. Please proceed.
Good afternoon, Chair, Vice Chair, and members of the committee. Thank you for this opportunity to present my testimony and express my full support of HB 582. My name is Caroline. Currently, I'm enrolled in the second year of the Master of Social Work at UH at Manoa. In Belgium, I have 16 years experience as a psychologist and psychotherapist in the field of child abuse. I was working within a multidisciplinary team composed of social workers, doctors, psychologists, and lawyers. During my years of practice, I have been confronted on many occasions with child victims, now adults who wanted to take legal action, but whose time limits had expired. Indeed, it can take years before one can dare to speak about the abuse. The question of making a complaint often comes long after this first step. Another argument in favor of this measure is related to the fact that some victims and survivors only dare to speak out when they themselves have become parents, auntie, uncles. At a specific stage of life, they want to make sure that their children are protected from their own sex offender. And if it's too late, it may not only victimize them and take away some of their reconstruction action, but it also may affect the records of potential future victims and prevents the recognition of the multi-recidivism. For this reason, I testify in strong support of this measure. Thank you so much for your time and this opportunity to provide my testimony.
Thank you very much. Next, we have testimony in support from Derek Carlin, Jezrael Feeney, Panepoli Mackenzie, Alexandra Cho, Will Karen, Dylan Ramos, Dr. Faith Joyner, and Nanea Lowe. Is there anyone else here wishing to testify on this measure? Otherwise, questions, members? First, Representative Ganadin.
Okay, I got you. To the Office of the Attorney General. Hi. Hi. I think all members realize, and everybody here realizes how difficult a subject this is to discuss, and we want to be respectful of victims and their families and the trauma that they have incurred throughout our communities. What is the statute of limitations for a criminal case?
I'm sorry,
For-
I do civil.
Maybe someone can help me.
The
What's the statute
prosecutor?
of limitations for a criminal case for minor sex assault?
Maybe you want to ask SATC.
Okay.
There is no statute of limitations.
No statute of limitations? There is none, okay. If there's different victims here, would it affect the ability for the victims to join as a class? This is, my mind is going to what happened just this year with Punahou School and in the last few decades with the Catholic Church. Would it, how will this implicate class actions probably before the federal court?
If the statute was extended to 32 years,
Yes.
it would really go on a case-by-case basis, but it would it would open the door to a lot more claims.
All right.
Thank you.
I'm sorry.
Yeah. Any other questions from you, Rep. Ganadin? Otherwise, I'll go to Rep. Chi.
If I can have the Attorney General come forward. Thank you so much for being here, and thank you for your testimony. I just want to clarify the language of the bill. In your reading of the bill, do you see this as applying prospectively?
Well, we read it as anybody, if it was passed. So it would be 30, if anybody made a claim, they would be allowed to make a claim up to 32 years after they turn 18.
So the way I read the bill, just to clarify, Chair, that we are not reopening the window period for any stale claims. So any claims that the statute of limitations have already expired, they would not be revived by this bill. So I see this language as only being prospective. So for example, if with your indulgence, Chair.
Please.
Under this bill, we're extending the statute of limitations from age 26, right, 8 years plus age 18, to age 50. If this bill were to pass today, because it's prospective, it doesn't help somebody who's 45 today. It helps somebody who's 8. And so I think maybe your testimony referring to claims that were made in the 70s or 80s wouldn't apply to this bill. Is that correct?
Yes, and I'm sorry, I do get that. The cases that we're handling now are from when the statute was previously reopened. So now, if this was passed again, we wouldn't be dealing necessarily with cases from the 60s, 70s, 80s, but we would be dealing again with cases even from the 90s. It'd still be dealing with the situation where witnesses and even the perpetrator himself are no longer around, right?
It would only apply, I think, to people who still have a valid claim today, right? So yeah, we are going back potentially 26 years, who still have a valid claim today.
Yeah.
But going forward, I think my question to the AGs is, could you work with, since you represent the state agencies and departments and have to defend them in court, on a going forward basis, ask them to retain these records, preserve this information so that in the future, should any lawsuits come up against the state, you would have those documents and records.
Yes, that's definitely in the works.
Okay, thank you so much. Thank you.
Thank you. Any other questions, members? Nope. Okay, thanks. We'll move on. Next, we have House Bill 586 relating to the judiciary. It requires the judiciary to develop, implement, and administer an automated court appearance reminder system that generates text message notifications for upcoming court appearances in certain types of cases and appropriates funds. First up, we have testimony with comments from the judiciary. Michelle Acosta. Nope. Testimony in support from the Office of the Public Defender.
Good afternoon, Chair Tarnas, Vice Chair Takayama, and members of the committee. Our office supports this bill. Currently, the judiciary does maintain a notification system called e-reminder, and it's a good system. All one needs to do is just go onto the website or fill out a piece of paper at court. We encourage our clients to sign up for this, because I do think it does make a difference in reducing the no-shows at court. Most people sign up for text, but some do email because they do not have a phone. But they do have access to public computers or computers that belong to friends and family. So we may want to expand the bill to include email. Although I don't have stats of how much improved the no-show rate has been since e-reminder has been implemented, I do refer to one study in my testimony that it reduced failures to appear by 21%. It's a good idea. I do think, though, we are missing a chunk of people because you have to go to court first. I think most people who get a ticket or who gets arrested, they're not aware of it until they go to court. So they may miss their first court appearance. I think if we have the police officers or whoever issues these tickets take down the phone number and input it into the system, we could cut down a whole lot more, because most people only go to court one time, especially with these infractions. And I know there's a bunch of default judgments that the state may get, but I think it's better if people show up to court and be able to have their day in court. Like the study indicates, most people just forget, and so other than that, I am available for questions. Thank you very much.
Thank you very much. Next, we have testimony support from Melissa Pavlicek, Opportunity Youth Action Hawaii, and testimony and support from Derek Carlin, testimony with comments from Ken Conklin, and testimony and support from Will Caron. Is there anyone else here wishing to testify on this measure? If not, questions, members? Representative Gannon.
To the Office of the Public Defender. Sorry for making you get back up. Thank you so much for your appearance today and for discussing how this bill might play out. What kind of amendments will we have to make to citations at the county level in order to do this?
Well, that, I believe the judiciary probably has, I think they're in charge of redesigning the citation. I guess there should be a phone number selection or a box that says, you check mark a box saying, I want text notification. Email's problematic. I know there's one testifier wrote down that we should have it. We can't catch everything. I think it may be too difficult on a citation, but at least in court, if they do make their first appearance, we could get that group in line. But you gotta ask the judiciary on how a citation, how to redesign a citation.
Follow up. Can you explain to the members and the public kind of what a public defender might often do to encourage their client to appear?
Yes, well, actually, when we do meet them at court or at our office when they come in for what we call intake or when we interview them, it's if they miss court, a whole bunch of things could go wrong. A warrant will issue. What would happen is that if you get stopped on the street for no reason or for whatever reason, you can get arrested because you're going to have to go to the police station and post a bail, whatever amount of that bench warrant was or the arrest warrant was, which is usually nominal for most people that can afford it. But a simple traffic ticket stop will result in an arrest. What will happen is that they'll call our office up if they miss it, or we may, sometimes we will contact them or try to contact them. Hey, you missed court. We would have to file a motion, the paperwork, the prosecutors get involved, and we got to get another court date. When people miss court, if it's basically for trial, everything just gets postponed. A lot of resources are wasted. We have witnesses, police officers that are brought into court for no reason because there's no trial anymore because someone didn't show up. And we've got to do it all over again. So it is reducing no-shows, I think, in the long run, will save time and money.
Thank you so much.
Mm-hmm. Thank you. Any other questions, members? If not, we'll move on. Thanks very much. Moving on to House Bill 862, relating to the judiciary, allows for judicial review of orders fixing minimum terms of imprisonment. First up, we have testimony in opposition from the Hawaii Paroling Authority. Mr. Chair, thanks for being here.
Chair Tarnas, Vice Chair Takayama, committee members. The Hawaii Paroling Authority stands in opposition to House Bill 862, as we believe there is already avenues in which these measures can be taken before the courts, as evidenced previously by Supreme Court rulings against the Hawaii Paroling Authority, which has changed the way that we have constructed the minimum levels of punishment for minimum hearings. I am available for questions.
Thank you. Next testimony is support from Office of the Public Defender.
Good afternoon again. James Tabe for the Office of the Public Defender. We support this bill. Currently, an inmate who wishes to challenge the parole board's decision on their minimum term setting, their only recourse is to file a petition for post-conviction relief under pursuant to Rule 40 of the Hawaii Rules of Penal Procedure. Basically, it's like a lawsuit that they have to file. We call it a Rule 40 petition. The inmate is not entitled to an attorney. They have to draft their own petition. It's usually with pen and paper, by hand, so they've got to craft that. There are forms available. Forms are a little complicated, and it's really meant, the forms are mainly for court errors, but they can apply it to parole board errors as well. But it's difficult to even navigate through these forms. So if this bill is passed, by the way, the vast majority of those who file these petitions never get a hearing because the standard is so high, is that a judge will review the paperwork, hear from the prosecutor's office in opposition, and they will decide whether there's a colorable or legitimate claim. If they decide no, there's no hearing. at all. No attorney is appointed, and that's the end of it. The cases that Mr. Hewin referred to that went up to the Supreme Court, those cases actually handwritten appeal. So, give a lot of credit to those two inmates or I know of two significant cases where they took it on themselves. So if we have this bill, we would be getting involved, we would be able to represent them, and it'd be like a motion for reconsideration, so to speak. The standards would be high. I think that was one of the questions brought up by the judiciary. I think my time is up, and everything should be in my written testimony. I am available for questions.
Thanks.
Thank you.
Please stick around because we probably have questions. Thanks very much, Mr. Tabe. Next, we have testimony in opposition from the judiciary. Anyone speaking on behalf of the judiciary today? On Zoom?
Aloha, Chair
Yes.
Tarnas, Chair Takayama, committee members. My name is Randy Pinal. I'm the supervising staff attorney at the Intermediate Court of Appeals. Thank you for allowing me to testify today. The judiciary opposes the bill because the existing Rule 40 process provides the best and most efficient way for an inmate to seek judicial review of their HPA minimum term order. Respectfully, it's not as daunting a process as the bill portrays it, and the bill actually provides fewer protections for inmates. For instance, the bill implicitly puts the burden on the inmate to provide supporting documents and transcripts with the motion that's filed in the sentencing court, whereas in Rule 40 context, the court could order the state to file those documents. The bill says that the sentencing court may review the minimum term proceedings, which means it's not required to do so, whereas in Rule 40, the circuit court is expressly required to review the petition and enter findings and facts and conclusions of law on that petition. Rule 40 also requires a hearing and appointment of counsel if the petition states a colorable claim. This bill does not require a hearing or appointment of counsel. Also, if the sentencing court decides to review the motion contemplated by this bill, then it must either modify the HPA order or send it back to the HPA. But the bill allows the inmate to file a simultaneous appeal from the same sentencing court order. So you could have an appeal pending in the ICA and concurrent proceedings remanded back to the HPA on the same issue, which creates confusion and risks duplicative proceedings. And the last point I want to make is that under this bill, all the inmate has to say in this motion to the circuit court is, I want you to review the HPA minimum term proceedings. That's it. It could be a one sentence. They don't have to state a legal claim. They don't have to state any facts supporting their claim like they do under Rule 40. The bill sets the bar so low that it's likely it's going to result in an increase in motions out in the circuit court compared to the number of Rule 40 petitions, and naturally more appeals for the ICA, potentially hundreds more each year, which would strain our resources. I'm available to answer questions. Thank you very much.
Thank you very much. Next, we have testimony and support from the Hawaii Association of Criminal Defense Lawyers. Not here today. And testimony and support from Will Curran. Anyone else here wishing to testify on this measure? If not, questions, members. Representative Ganaday.
Senator Hune with the Hawaii Paroling Authority. Good afternoon.
Sir.
Yeah, firstly, thank you for your years of dedicated service to the state. Would this bill, if it's passed, address the high percentage of inmates that max out their term of imprisonment prior to their release? By max out, I mean those individuals who qualify for prospective release through parole, but then they find, for a variety of reasons that they're right to the edge of it and then they're released fairly shortly thereafter.
I believe this bill focuses on the setting of minimum terms. One, minimum terms that the Hawaii Parole Board has set when it sets its minimums, usually within 6 months after admission into the facility. So as far as maxing out, unless you're talking about some of the short-term sentences that have been rendered by the courts, such as 24 months or 30 months, it may not apply.
Okay. And in regards to those 24-month or 36-month, those are often served in OCCC, right? Here on Oahu.
No. When the court has, there is a provision in the current statute, especially that lately has been for promoting of a dangerous drug in the third degree. Courts have been sentencing to 18 months, 24 months, as much as 30 months on an open 5 prison sentence.
How do you feel about the Office of the Public Defender continuing to represent many of these inmates and assist them with their various legal issues, including those covered under this bill?
Well, my personal bias and professional opinion focus that or state that the Office of the Public Defender does an excellent job in representing inmates. Biggest problem I know Mr. Tabe has is trying to fill vacancies. But, you know, as far as the representation that I've seen them from back in the 80s to currently at parole hearings, Office of the Public Defender does a great job.
Thank you.
Vice Chair Takayama?
Thank you. If I may call up Mr. Tabe, and let me, Chair, again disclose that my daughter is an associate public defender. Mr. Tabe, how would you heard the concerns expressed by the judiciary as to their views that the proposed measure would actually weaken some of the standards in place now, such as not requiring a hearing and not requiring appointment of counsel? What are your thoughts?
Yeah, I compare these, if this bill passes and there is this review by the circuit court, I would compare this to when a judge sentences a defendant, in court. Oftentimes, there is a 90-day window where the defense or the defendant can file a motion for reconsideration. Fortunately, most of those motion for reconsiderations, when they get a hearing, are denied because there is the judge decides that you haven't gave me anything new, so the motion's denied. Some judges even deny it without even a hearing because it's just someone just complaining about their sentence. So it doesn't take much effort, I think, from all parties. Not everyone, not even close, a small percentage file those motions. Once a defendant is unhappy with their sentence. And even a smaller percentage of that actually file an appeal, which usually gets denied by the appellate courts because it is an abuse of discretion standard. We give judges a wide latitude. Here, as well as with the parole board, I would imagine if people are just complaining about, oh, why did he give me 36 months when I deserve only 24 months? That's probably going to be left alone because, or it should be quick, because I don't think that the judge, though they just may think that it's high, will not think that there's an abuse of discretion by the HPA. Now, if the HPA doesn't follow the guidelines, because there are set guidelines, and Mr. Hune, I'm sure, will not violate these guidelines, but sometimes it happens. When the parole board may miss something, we can point that out quickly to the judge, and the judge, if they find it, we can resolve it quickly rather than going through the process of it's well written. A defense attorney will write it, write the motion, and we could get it litigated properly. And I think it would be, it's more efficient rather than, it's efficient. The system is efficient not for the defendant or inmate. It's efficient for the system right now, because, like I said, it's pen and paper. And to get the information, even just to get information, what case number was my, it's very difficult for the inmate to do it alone. Now, when I was practicing as a frontline deputy, I would at least give my client the information, and I helped them fill out the form, to the best I could. But I said, you got to do it yourself, get the stamp, mail it to the courts, hope and pray it gets there, and whatnot. But that would be my limit, and I didn't do it for that many cases as well, because it is beyond the scope, but sometimes I would help out. But it is, it's not efficient for the inmate. It's very difficult to go through this process alone.
And you heard the concern on the part of the judiciary that this may result in an inundation of cases before the intermediate court.
I don't think there'll be an inundation to the intermediate court, because frankly, I would imagine if we had a client who's upset at the HPA term. We file a motion with the court, the trial court at the circuit court level, and they say, no, HPA was correct or didn't abuse its discretion. Filing an appeal there, I don't think there's going to be that many. Number one, the appellate process takes 2 years. If we're fighting for something about a 2-year sentence, it's going to be moot as is, and that's what we'll explain to our client. And when you have attorneys there, we can, if they have an attorney, we can explain to them the pros and cons of filing this appeal, or what the purpose. Right now, when the courts deny the Rule 40 petition, they'll just file the appeal on its own, regardless of what happens. So I don't know whether, I may be wrong, but I don't see inundation of cases on the appellate court level. Of course, there'll be, an increase at the circuit court level to hear these motions, but.
Thank you. Thank you, Chair.
Thank you. Representative Gannon.
Mr. Tue, nationally, there's a conversation about decriminalizing certain drug offenses. For example, what we consider possession of a dangerous drug is being decriminalized in places like Washington State, Washington, D.C., other places like that. Do you think that, if, let's say you had, I'm just giving you a fact pattern, like let's say you had a client who had found themselves clean and sober while in the custody of the state, they might try and seek a judicial review so that they could get an earlier release and be placed into treatment or be returned back into community, like given that they were found guilty of a non-violent drug-related offense?
Well, let's just back up. I don't know if I'm going to answer your question. What this would do is, let's say if a judge disagrees with the HPA as to the minimum setting, and then we'll order the HPA to redo it, and the HPA gives them a lower minimum. A minimum setting doesn't mean the person gets released at the end of the minimum term. When the HPA imposes a minimum term of, let's say, 2 years, at the 2-year mark, they are eligible for parole. So at that point, they're going to have to appear before the HPA, and Mr. Hugh, correct me if I'm wrong, then they will decide whether he or she deserves to be released on parole. So just because the HPA sets a low minimum, or the judge orders it the minimum be reduced, this inmate will still have to go see the parole board at the, let's say, at the end of the minimum term and ask, can I be released? I did A, B, and C. I met all your conditions. And the parole board decides that. If it's denied, they'll come back, anywhere from 1 month to a year later and go, and try to get released again. So it's just the setting of the minimum term doesn't mean release. It just means that's when you get your next hearing, and to prove to the board that I'm good to be back in the community again. So that's why I think, it's the remedy seeking on appeal. Now, mostly this bill is when, if they didn't follow, the guidelines that they're supposed to. So at that point, we could raise that and we could help the system, so to speak, because it probably may not help that inmate. But it's just the minimum setting, and I don't know if we're making more. So like I said, the minimum setting is only your next parole hearing date. That's what that's really for.
Thank you. Any other questions, members? If not, thank you very much. Let's move on. House Bill 863, relating to initiation of prosecution, specifies that a subsequent attempt to prosecute a felony using an alternative charging method after the first attempt has failed shall not be permitted unless certain conditions are met. First up, we have testimony from the Attorney General. Welcome.
Good afternoon, Chair, members of the committee. Amy Murakami, Deputy Attorney General. The department offers comments on this bill that would amend Hawaii Revised Statute 8011 to prohibit subsequent attempts to initiate a felony charge after a failed attempt unless certain circumstances exist. but the bill does not address the reinstatement of complaints to initiate cases in the circuit court. And it's very important for the administration of justice that preliminary hearings to initiate felony cases be allowed. And so for these reasons, this department is requesting that either this bill be amended to permit complaints to be filed to initiate cases in circuit court, and in particular for preliminary hearings to be reinstated as a means to initiate felony charges, or that we would respectfully ask that Senate Bill 36 be allowed to be the vehicle to accomplish both reinstating preliminary hearings as well as to address the issue of limiting prosecution's discretion in seeking subsequent attempts to charge a case after a failed attempt. Thank you very much for the committee's time. I'll be available for questions.
Thank you very much, Deputy Attorney General Murakami. Next, we have testimony and support from the Office of the Public Defender. Mr. Tabe.
Good afternoon again, Chair Tarnas, members of the committee. The Public Defender supports this bill. This bill will allow the prosecutor to initiate prosecution not only via grand jury, but also through preliminary hearing, and we agree that that's a good thing. This bill also codifies Associate Justice Nakayama's concurrence in State v. Obrero, which will allow the prosecutor a second attempt, but only under the condition that there's new evidence. And we think that the bill should remain that way. I know the prosecuting agencies would like to pattern after SB 36. We disagree with the added provisions under SB 36, where there's a good cause exception and a grand jury misconduct or counsel misconduct section. And one thing we'd like to add is that in our testimony, we asked the bill be amended to add a notice provision, because these grand jury proceedings are secret, we don't know whether there was a previous attempt when we get a case. We usually find out by accident when we talk to this prosecution witness. They go, when I testified before, I go, what? You testified before? And then we find out, oh yeah, I went to the grand jury 2 times, and then that's when we find out. Now we tell our attorneys to ask for whether there was prior. It's important that we know, because that when we could challenge, why did you go twice? Or plus witnesses testify, to see if the 2 testimonies are different. We'd like to compare testimonies of witnesses to see if they're being credible, or if they're consistent or inconsistent. So we'd ask that since we have this bill vehicle in front of us, we add that notification proceedings. The language suggested, we're not bill writers, so if someone can improve the language that we suggested, better. Okay. So otherwise, we stand on our testimony, and I will be available for questions.
Thank you very much. Next, we have testimony in opposition from the Department of Prosecuting Attorneys, City and County of Honolulu. Trisha Nakamatsu.
Good afternoon, Chair, Vice Chair, members of the committee, Deputy Prosecutor Trisha Nakamatsu, appearing on behalf of the Honolulu Prosecuting Attorneys Department. We are in opposition to this bill. As indicated by the Attorney General's office earlier, Senate Bill 36 actually presents more of a complete solution to all of the opinions that were issued by the Hawaii Supreme Court in State v. Obrero, primarily the majority opinion, which of course the need that our departments, most of the prosecutors were most concerned about, is bringing back the ability to use preliminary hearings as a charging mechanism. So HB 863 currently does not contain any language pertaining to that. We do note that the language in SB 36 does address the issues that HB 863 addresses, to the extent that Senate Bill 36 would limit the prosecutor's ability to come back after receiving a no bail or finding of no probable cause from preliminary hearing or grand jury. The ability to come back and try to present the case again would be limited to certain types of circumstances. We do feel that the language in SB 36 was very carefully crafted. There were a lot of back and forth discussions over the course of approximately 2 months this past fall with the various prosecuting attorneys' office, our understanding is also the Public Defender's Office, and with Senator Rhodes, and then Chair Nakashima as well. We would like to point out that this is at the time of the State v. Obrero, after State v. Obrero came out, there was a lot of discussion and a lot of turmoil in our courts about whether a special session would be needed. And I can address that later if there's more questions.
Okay.
Thank you.
Thank you very much. And finally, we have testimony in opposition from the Hawaii County Office of the Prosecuting Attorney, Keldon Walchin. Please proceed.
Aloha, Chair Tarnius, Vice Chair Takayama, and committee members. Hawaii County Prosecuting Attorney Keldon Walchin. We are in opposition to this bill. We ask that the committee defer this bill, allow Senate Bill 36 to be the vehicle to amend Hawaii Revised Statutes 801-1. We share in the sentiment and comments made by Deputy Prosecuting Attorney Nakamatsu with the Honolulu Prosecutor's Office. But I do want to express my appreciation for the committee's diligence in addressing the impact of the Supreme Court's decision in State versus Obrero as soon as possible, to address public safety concerns across our state. That being said, it is our belief that the 4 county prosecutors are all in agreement that Senate Bill numbers 36 addresses concerns raised by the law enforcement community. It restores prosecutors' abilities to initiate felony prosecution by way of complaint and preliminary hearing. And as has been the common practice for the past 40 years in Hawaii, and it also affords protections for the criminally accused, additional protections that weren't in place in the past. I'd also like to share that since the September 8th Obrero decision, our office has worked in collaboration with the Third Circuit Judiciary to increase grand jury opportunities on Hawaii Island from 2 times to 8 times per month. Nevertheless, we were still presented with a difficult time period where there was no available grand jury opportunities from the end of December until about the 3rd week in January. Despite increased grand jury opportunities, inability to initiate felony prosecutions by way of complaint and preliminary hearing, subjects victims of crime to being unnecessarily inconvenienced, traumatized by requiring subsequent testimony at more than one evidentiary hearing in order to successfully commit a felony case to the circuit court. It places undue strain on the limited resources of police and of the prosecutors. For example, since the Obrero decision, our office
Keldon, if you could wrap it up, that'd be great.
Sure. On more than one occasion, we've had to present cases at a district court preliminary hearing at the same time presenting a grand jury presentation on the opposite side of the island. This frustrates, inconveniences, and places additional burdens on not only police and prosecutors, but civilian witnesses, but more importantly, the victims and their families too. We submitted our written input and asked the committee to defer House Bill 863, asked that the committee consider Senate Bill 36 as soon as possible. I remain available to answer any questions. Mahalo.
Thank you, Prosecuting Attorney Walchin. Is there anyone, that's all the testimony we received on this measure. Is there anyone else wishing to testify on this measure? If not, questions, members. Representative Ganadin.
To Ms. Nakamatsu. Thank you so much for your work in crafting the other bill and in convening grand juries. You were explaining to the committee, to the public, what happened in September as a result of the Obrero decision?
Yes, as most people are aware, immediately following the State v. Obrero decision that was issued by the Hawaii Supreme Court on September 8th, 2022, immediately all of the pending cases in which our office or any of the prosecutors had charged via preliminary hearing immediately became essentially, although very few of them actually have gone through motions for ultimate finding, but the charges were then legally insufficient based on the majority opinion in State v. Obrero. So as a result of that, hundreds of cases thereafter had to be recharged via grand jury hearing because that was the only option left pursuant to State v. Obrero. It created a backlog of cases as there wasn't, as was previously indicated, there wasn't enough grand jury hearings to accommodate all these cases and to recharge them in addition to all of the new felony cases that continued to come in that also had to be charged only via grand jury hearing. So that, for on Oahu, that was approximately 174 cases for pre-Obrero, in addition to the new cases coming in. And of those, I believe 92 were pretrial felons who were being held in custody pending trial. So what happened after Obrero is there was another case called D'Angelo, Save D'Angelo, in which a writ was filed. Basically what happened was that in that case, defendant's charges were found legally insufficient. The cases, the charges were, was it dismissed, I believe? But they were no longer able to stand, and the issue was whether D'Angelo could continue to be held without legally sufficient charges. There was a constitutional question of whether that was permitted or should be permitted, and so there was a lot of, that was one of the primary issues that the prosecutors were concerned about, is what happens if the Supreme Court comes back and says, no, it's not constitutional to hold these people since they're charged, they were not legally sufficiently charged. And then all 92 of them on Oahu and a number of others on the other counties would ostensibly have to be released in some fashion, in some timeline, and we didn't know what that would be. There did seem to be a distinct possibility of that happening, which was very, very problematic, and it could, while we acknowledge, of course, everyone is innocent until proven guilty in a court of, in a criminal case, it would present, we felt, a serious public safety risk if all 92 of them had to be summarily released until their cases could be brought back via grand jury. I'm sorry, I can stop anytime.
No, it's okay. Because the Office of the Prosecutor here in Honolulu asked for a special session of the legislature, it came to a lot of our attention. As a result of Obrero, were any of these 92 people actually released?
Ultimately, no, because in and part of the main reason is that D'Angelo writ was actually denied. So it turns out that the Hawaii Supreme Court found that it was constitutional based on one of the court rules that these people could be held even after their charges were found insufficient until such time as their charges could be brought back in a proper manner.
So one more quick follow-up, Chair. Have you caught up with the grand jury indictments?
No, not on Oahu. I'm sorry, if it's all right with the Representative Chair's indulgence, I would like to point out that the D'Angelo writ wasn't decided until November 7th, I believe, of last year. So it was after a lot of these special session requests and discussions had already been pending for quite some time. And then after that, there was a motion for reconsideration that wasn't decided until December 6th. So just to set some idea of the timeline that we were looking at while I was still outstanding.
I only asked the question because I just want to make it clear to the public that no individual charged with a serious crime was released back into the community as a result of this case. So
I can't speak for the neighbor islands. I'm not aware. I think there were some cases that they thought was kind of gray area, but they were able to find other mechanisms. I mean, there were other valid mechanisms upon which, yes, I believe everyone was held.
Thank you.
Thank you. I appreciate that, Representative Gannon, and just making the public aware that there weren't any individuals released who are a potential threat to the community.
Absolutely.
Yeah. Thank you. Other questions, members? If not, let's move on to the next measure.
Sorry.
Oh, yes.
Sorry, Chair.
Rep. Gannon.
I got stuck on one train of thought. To Mr. Tabe.
I'm going to move the mic right next to your mouth.
Yeah. Well, being on this committee. In your testimony, we don't have SB 36 before us, but it appears the Office of the Public Defender prefers this draft over that one. And, you know, in lieu of having this conversation in late April or May, you know, when we go into committee and we're all overwhelmed, can you tell us why the Office of the Public Defender has issues with the good cause provision that is absent in this one but is present in SB 36?
Well, first of all, if I try to recall my testimony here, good cause is just a vague term. And number one, when the prosecutor is going to want to go back to the grand jury again, they're going to go to the judge and ask for good cause. When they ask for good cause, there will only be one party represented, the state, because these proceedings are secret. The person that's being indicted or trying to be, is under suspicion doesn't have counsel usually unless they're very wealthy and have hired private. And even then, they don't even know if grand jury proceedings are going on. So this proceeding to ask for good cause is basically non-adversarial. We object to that. Number two, the standard of good cause is just so vague. I know there was a comment that there is case law defining good cause, but I'm afraid that, let's just say in the recent news, there's this North Shore killing, right? Let's just say that the prosecutor's office, which they usually hardly ever do, but let's just say they didn't do it right and presented the evidence. And all of a sudden, the grand jury said no bill. Well, I can see a judge saying, oh, the charges are so serious, or the facts are so serious, that's good cause. So especially when there's only one party present to argue the case. So that's why we have a problem when we have these standards where that will need to be litigated. That's the reason why. And it's the same as for the other exception, the misconduct section. It's just that, again, only one party is going to be represented at this hearing. Usually when there's juror misconduct in a regular jury trial or petite jury, it's just the way the Constitution is set up, it benefits just one side, and that's the defense, because the defendant has the rights here. So for the reasons I stated in our written testimony, just to keep this brief, we do not, we object to the language. And, we try to work it out with Senator Rhodes over the summer and with the prosecutor's office, but we objected to those two provisions, and it still made it through, so.
Okay, thank you. Thank you. Any other questions? If not, let's move on. House Bill 864, relating to criminal justice, establishes and appropriates monies for a 4-year Pacific Cultural Court pilot program in the Family Court of the First Circuit. First up, we have Jesse Hall, Judiciary, in support. Thank you for being here, Judge.
Thank you. Afternoon, Chair Tardis, Vice Chair Takayama, members of the committee. The Judiciary stands in support of this bill, and I'm available for any questions. We will stand on our testimony.
Thank you. Next, we have testimony and support from the Office of the Public Defender. Thank you for your patience all this time.
Aloha. My name is Darcia Forrester, and I am the Family Court Supervisor at the Office of the Public Defender, which includes the Juvenile Division, which is why I'm testifying on this bill. So we support the concept, and we definitely think it's a good idea, but we think we might need to do some homework before we jump in. I just did a little bit of research before coming today, and there are a lot of models that we can look at. There are cultural courts in New Zealand. There's the Rangatahi courts for Maori youth. There's the Pacifica Youth Court. There's also in Canada, the Manitoba Indigenous Youth Justice Program. There are versions of these types of courts in Alaska and in Australia. There's also the Navajo Nation Peacemaking Program, which is specifically for youth. And there is also an organization called the National Youth Court Center. And they, on their website, have 4 different models that can be looked at on how to approach an indigenous-based youth program that is focusing on a person's culture. Hawaii is a little bit more complicated than, let's say, New Zealand. New Zealand already has what's called a marae system, so they have infrastructure that's already available to them in the form of cultural centers that different tribal groups will have throughout the nation. We don't have a marae system here in Hawaii, so we would have to do some research to figure out where it would be appropriate to say, if we were going to focus on Native Hawaiian youth versus youth from Micronesia. So we're just asking that we might need maybe a task force to really do a little bit of research before we jump in this pool, but we fully support the purpose of this court. Thank you.
Thank you very much. Next, we have testimony and support from Judith Clark, Hawaii Youth Services Network. Testimony with comments from Derek Carlin, and testimony and support from Will Curran. That's all the testimony we've received on this measure. Is anyone else here wishing to testify on HB 864? Seeing none, questions, members, Representative Ganadin.
To Judge Hall. Good afternoon, Your Honor.
Afternoon.
I'd like to just convey to the members that I'm so impressed to have a member of the judiciary here. I think it's the first time I've ever seen it done.
We are grateful.
Yeah.
Thank you.
What kind of changes are already going on in place at the juvenile court to address culture?
So we do have a diversion program through our, what we call Alder Street, or the former Alder Street, since we just got rebuilt, that we are going to start creating programs that are culturally sensitive with our community partners. It's through those programs that we create and test through our diversion youth that we are hoping to use to create the cultural court.
Again, Chair. And I'm assuming this is to acknowledge the overrepresentation of Native Hawaiian youth in the justice system, as well as Pacific Islander youth in the justice system that we become, unfortunately, quite aware of.
Yes, and in fact, in our testimony, you may see that for the fiscal year of 2022, statewide Native Hawaiian and Pacific Islander youth accounted for 48% of those that were arrested, 49% that were referred to family court, 50% of the petitions filed in family court, and 63% of the youths that were detained.
Let's see. What kind of partners might the judiciary work with in developing these kinds of basically off-site court proceedings?
We're looking at various community partners, especially with regards to Native Hawaiian community, Liliuokalani Trust. We'd like to reach out to Kamehameha schools. With the Micronesian community, where we have mentioned it to WOW, We Are Oceania, and they are excited about having further discussions and possibly partnering also.
All right. And one last. Mm-hmm. Is there a danger in essentially institutionalizing a minor by bringing them to court in lieu of addressing their interactions with the justice system in their own communities and with their own culture?
Absolutely. Every time we bring a youth to court, it does affect them traumatically, and it's another layer of trauma that, and for most youth, the reason they're even in court is because they have trauma that they're dealing with. So if we can limit the trauma of having to come to court and reconnect them to their community and their culture, we believe that that will have a better outcome overall. And we're hoping that will have a ripple effect to lead to lower incarcerations into the adulthood.
Thank you.
Thank you very much. Other questions? Representative Souza.
Thank you, Judge Hall, for being here. I just had a question about just the application of this sort of alternative sentencing program, or the unequal, perhaps, application where, say if you have Native Hawaiians participating in the program, but like another cultural group is excluded for whatever reason. I mean, how does that work as far as unequal opportunity or an equal opportunity problem, essentially?
Well, being a state agency, we personally can't exclude. But there are, because some of our partners that will be having the programs, they are limited to only helping maybe the Native Hawaiian youth or maybe the Micronesian youth. We may not be able to send non-Native Hawaiian youth to their particular programs, but that's where we're hoping to create a number of programs. So for situations such as that, a youth, we'd still have a program to send them to. So just because a youth is not Native Hawaiian or a Pacific Island, if they're interested in participating in this court, we are willing to open our arms to them, because I think, as everybody knows, it doesn't take blood to feel that you are Hawaiian or have Hawaiian-ness or to be a fan of the culture. So I think all youth should have the opportunity if they wish.
Thank you for that explanation. You answered my question again. Thanks.
Thank you.
Thank you. Any other questions, members? If not, thanks, Judge. We'll move, oh, yes, yeah. Anyone, do you have an idea how much appropriations you would need?
So I know that the bill asked for one coordinator position. What we have discussed is the coordinator position or a position we do not need right up front, but we did do some calculations, to be honest, and it would probably be in a neighborhood of $400,000 to have the staffing and the support necessary for the program. But again, we don't feel we need that right up front. It could be something that we could come back to the legislature to ask for at a later date that would be something above what the judiciary's budget would account for.
So, at this point, you don't think we
Well,
should ask for appropriations?
It would be nice, to be honest with you, but to create appropriations to create a position at this moment, we need the programs in place
Right.
before we can create the position.
So if we were not going to be funding a position, what would you suggest being appropriation that we'd be looking at for the next 2 years?
I'll be honest with you, I'm not sure.
Okay,
I would have to ask.
thank you. Quick follow-up. Yep.
Yeah, to follow up on the chair's comment, there is a good amount of interest and funding going to this in the community. Right? I'm aware of a $20 million Kellogg grant going to Partners in Care.
Yes, and there is a portion of the Kellogg grant that does require some indigenous programming. We have been in discussions with Partnerships and Development about how that can be possibly used also.
So not all of this would be coming from the state. A lot of this is coming from already allocated monies going to
A lot of this
nonprofits.
is going to be coming from our community and our partnerships, yes.
Thank you.
Okay, thank you. Thanks very much. Okay, let's move on. House Bill 829, relating to court-appointed attorneys, requires the court to appoint counsel to indigent parents upon the filing of a petition for custody or family supervision and make every effort to do so at the first hearing attended by the parents. First up, we have testimony from Judge Hall. Welcome back.
Thank you again, Chair, members of the committee, Vice Chair. The Family Court offers its testimony. We take no position, but add comments. We are here for any questions that you have, and we'll stand on that testimony.
Great, thanks. We have testimony in support from the National Coalition for a Civil Right to Counsel, John Pollack. Testimony in support from Hawaii Coalition for Child Protective Reform, Marilyn Yamamoto. Testimony in support from Opportunity Youth Action Hawaii, Melissa Pavlicek. And testimony in support from Hawaii Coalition for Child Protective Reform, Nonohe Potello, and testimony in support from Will Karen. Is there anyone else here wishing to testify on this measure? If not, questions, members? I have a question for the judge, if I could ask. Thanks for your testimony on this, and it sounds like there's a timing problem here.
Correct.
Do you have suggestions how we can fix that?
Well, to be honest with you, right now, we are doing essentially what is being requested of us. When we get the petition filed with the court, we are given at that time the information on how to contact parents, if that is available. Our staff then goes ahead to attempt to contact the parents to qualify them prior to the hearing and provide them with the information of an attorney if they qualify. There are situations where we're unable to contact the parents and they may just show up at the hearing, and we may be able to present them with an attorney at that time.
So, am I to understand you're already carrying out what this measure describes?
Correct. It's just when it says if you appoint somebody,
Yes.
you have to appoint within 3 days or continue it, that is not possible
No,
because we
that's
don't
not.
get the petition until 2 days before.
Okay. But the system you're using is a system that works within the timeline that you have to follow.
Correct.
Got it.
As
But
long
you-
as we have the contact information, we're able to have an attorney for that parent prior to the hearing.
Okay. Okay, thank you.
Thank you.
Any other questions, members? If not, on to the final measure of the day. House Bill 1335, relating to arrests, provides that after making an arrest, a police officer may issue to the arrestee an appearance ticket that states the date and time of the initial court appearance, and thereafter release the arrestee from custody. Broadens the range of offenses for which a police officer may issue a citation in lieu of making an arrest, and provided that certain conditions are met. First up, we have testimony In opposition from the Attorney General. Thank you for your patience.
Good afternoon, Chair Tarnas and members of the committee. Lauren Nakamura, Deputy Attorney General, on behalf of the department. The department supports the intent of this bill, but opposes and recommends deferral due to the significant concerns raised in our written testimony. To summarize, first, there's been no recent assessment of the reforms already enacted per the recommendations of the 2018 pretrial task force. If anything, data suggests that the reforms are working to reduce pretrial detention. For example, OCCC in 2018 had 127.4% overcapacity, has now been dropped by 13.8%. HCCC in 2018 was 184.5% overcapacity, and that number has dropped by 53.5%. And lastly, MCCC in 2018 had 159.5% overcapacity, and that number has also dropped by 48.5%. Additionally, the listed requirements of the appearance tickets would not meet our notice requirements for charging language under the current case law, and the bill does not provide any guidance on how to initiate felony cases in circumstances where citation is given rather than arrest. In such cases under this bill, prior to the initial appearance of the court, there would be no judicial determination of probable cause, no review by prosecutors where we could potentially decline charges, and also it's unclear how long after the arrest the initial appearance would be, which would obviously cause logistical issues not only for the court but prosecution as well. Additionally, the limits on citations, where citations would be allowed, are insufficient to protect public safety, noting the specific serious offenses noted on page 2 of our testimony. Additionally, it does not include the risk of recidivism, which is a factor specifically noted in the 2018 pretrial task force report in their #1 recommendation. And lastly, there is insufficient consideration to the victim rights noted by the presenter in yesterday's informational session. This consideration in particular is part of the national trend in reform. Lastly, the bill places an onus on officers at the scene of arrest who don't have a full picture or information to make these kinds of determinations. They are given less info than what would typically be given to the judge in a custody situation, as the framework is currently. And lastly, for example, in a situation of a habitual property crime, under your framework, under the proposed framework, because there is a mandatory imprisonment, it would be a citation could not issue. However, in these situations, obviously, the arrest could be for a theft 3 or a theft 4. If the officers do not have the proper rap sheet for the defendant, or is unable to get that kind of information in a timely fashion, they could not make the determination of whether or not that particular defendant would be eligible for habitual property crime. And lastly, as noted in our written testimony, that the prosecutors are not there at the scene of arrest to assist in these types of determinations. And finally, we point to the conflicts we pointed out in the 3rd page of our testimony, where there is language conflicts with chapters 803, 804, and 710. So, and available for questions.
Thank you very much. Appreciate your comprehensive testimony. Next, we have testimony in support from the Office of the Public Defender.
Hi, good afternoon, Chair Tarnas, Vice Chair Takayama, members of the committee. My name is Lee Hayakawa. I am the Chief Deputy at the Office of the Public Defender. The Office of the Public Defender supports the goal of HB 1335 to reduce the numbers of arrests for certain offenses, including felonies, misdemeanors, petty misdemeanors, and violations. This is a promising step in addressing issues of overcrowding in Hawaii's jails and prisons, the impact of unnecessary and disruptive arrests in our communities, and the disparate treatment of indigent defendants in the criminal justice bail system. While the OPD agrees with the goal, the Office of the Public Defender has concerns regarding the actual application of HB 1335. I will be here available for questions. I do feel compelled to respond to some of the numbers that the Deputy Attorney General, I guess, provided for the committee. We had testimony, I guess, just last week on a very similar bill, HB 1336, at which time I talked about overcrowding in the prisons. So although numbers may have gone down since, is it 2018? OCCC, MCCC, and HCCC are all still above their operational capacities. Again, while their numbers have gone down, they are still above those operational capacities. Again, thank you for the opportunity to testify on this bill. Thank you.
Thank you, Mr. Hayakawa. Next, we have testimony in opposition from the Department of Prosecuting Attorney, City and County of Honolulu.
Chair, Vice Chair, members of the committee, Deputy Prosecuting Attorney Mark Tom for the department. Department is in strong opposition to House Bill 1335. First off, I would concur, obviously, with the succinct recitation by the Attorney Generals on this bill and its effectiveness. Specifically, we would just kind of flesh out and point out some of the things that the Attorney General's already pointed out. There's just a lack of procedure mechanisms and mechanisms that are infused in this bill or worked out or fleshed out in this bill that would allow for this system to kind of properly work as it is intended to. Additionally, the department would point out that under Act 179 back in 2019, part of that bill included for expedited bail reports. And that was, I believe, for like 3 days, the bail reports would come in. And why that's important is because this bill kind of almost sidesteps that process, which is very important because a lot of charges that are petty misdemeanors, they don't really assess dangerousness. And that's, I think, what we want to make sure that we're looking at is the dangerousness. Just because it's a petty misdemeanor doesn't mean that this individual is not dangerous based on their prior history. So making sure that that occurs is very important. Last, I would want to point out that although this allows for officers to cite instead of in lieu of arrest, it also works the opposite way in some respects, that it might force or tie the hands of the officer to actually arrest on a low-level petty misdemeanor offense just because it could fall under the parameters in this bill. So it actually might have the opposite effect to some degree and cause arrest for individuals that might not have been done without this bill. So we'll be here for testimony.
Thank you very much. And finally, testimony in support from Will Karen. Is there anyone else here wishing to testify on this measure? If not, questions, members. Representative Gannon.
Mr. Tom, I'll try to be brief, Chair.
Okay.
Mr. Tom, from the Office of the Prosecutor. My understanding is this bill is a may but not need issue an arrestee an appearance ticket. So this still offers a wide latitude for the prospectively arresting officer. Is that correct?
That is correct.
So we're not saying that an officer shall give someone a ticket in lieu of something prospectively dangerous. Is that correct?
That is correct. As opposed to, I believe another House bill that had a more shall. This does have just a may or allows officers discretion.
Yeah. I know you're not the Honolulu Police Department, but what kind of practices were in place with your office during COVID? And what kind of guidance were you working under with the Honolulu Police Department, in not arresting people and giving them citations?
That rep would probably be something that you would have to check with HPD.
Okay. But there were many more citations given in lieu of arrest. Is that correct?
Are we talking about a particular charge, or are we talking about just in general across the board?
Just in general across the board.
I would have to check specific numbers, but that potentially could correct.
Okay, so there was, it was in the news a lot that there was a lot less arrests during COVID and no major increase in crime, a statistically significant increase in crime. Okay. Is that correct?
I'll take your word for it without doing the further research.
Thank you.
Thank you.
Other questions, members? Representative Takayama.
Thank you. If I could call up the Deputy Attorney General. Ms. Nakamura, in your testimony, you made reference to the 2018 Criminal Pretrial Task Force. Was the State Attorney General a part of this task force?
Yes, we had members that were part of the Criminal Pretrial Task Force.
And was this recommendation not one of the recommendations issued by the task force?
There are portions of this bill that were part of the recommendations. The point of my testimony was to point out that not all of the recommendations in its entirety was taken up by this particular bill per its language.
Okay, all right, thank you, Chair.
Thank you. Any other questions, members? If not, thank you all for testifying today. I would like to take a brief recess before we go into decision-making. Recess. We are reconvening the Committee on Judiciary and Hawaiian Affairs Tuesday, February 7th for decision-making. So first up, we have House Bill 1041 relating to fireworks. I want to see action, not more talk. And so another task force just seems to be more talking. So I would welcome, before I make my recommendation, if anyone else wants to make comments about another task force, you're welcome to. Otherwise, my recommendation is to defer. Okay? Next, House Bill 809. I would like to move this out with an HD1, incorporate the amendments recommended by the Department of Law Enforcement and the Attorney General, defect the effective date to 6/30/3000, keep a blank appropriation, but put into the committee report $750,000 per year. I'm comfortable with the language that's in the bill that allows them the flexibility to move the container as needed to another part of the port in order to inspect it safely. So with those changes, I would like to move out on HD1. Questions or concerns? Seeing none, Vice Chair for the vote.
Voting on House Bill 809 as amended, Chair and Vice Chair vote aye. Representative Ganadin?
Aye.
Representative Holt?
Aye.
Representative Hashimoto?
Aye.
Representative Ichiyama?
Aye.
Representative Iligan?
Aye.
Representative Kong?
Aye.
Representative Mizuno?
Aye.
Representative Souza?
Aye.
Chair, your motion's adopted.
Thank you. Moving on to House Bill 145. I appreciate the State Fire Council coming back and trying this again. I think this is trying to address the problem of illegal fireworks by further limiting legal fireworks and people who are getting the proper permits to be able to celebrate on New Year's Eve and on Chinese New Year and 4th of July. So I don't think this is really going to address the problem. So that's my opinion on this. Anyone else want to express opinions before I give my recommendation? Okay, my recommendation is to defer this measure. Next, House Bill 208. After hearing testimony on this, I would recommend to the introducer of the bill to go work with the programs that are already going on to try to address the real serious problems of criminal activity in Waikiki. So I recommend to defer this measure. Next, moving on to House Bill 480. This is an important measure to the introducer, who is on our committee, and in reviewing the various recommendations and testimony, it still needs more work. Before I make my recommendation, I offer the introducer to provide some comments.
Thank you, Chair. Chair, the County of Hawaii and Finance brought out some comments on changes that we could make. The intention of the bill is to be able to modernize the system to accommodate the aging vehicles so they could fall into the category of classic cars. And their suggestion is to eliminate the street rod and the street rod replica and change it into special interest vehicle. The problem with that is that I need to be able to, like you mentioned, is broker the support with the collectors and the users and make sure that their concerns are also addressed. But if I were to eliminate the whole reference of 35 years, then the 1967 static year is still going to be present. And if that year is still there, it won't address the aging vehicles as they age. Finance did mention that we could add in of any age, but I want to make sure before supporting that amendment that it doesn't affect the way the industry would be affected. So I would prefer to first discuss it with the industry as we move it forward into finance. And my recommendation is to accept one of their amendments, which is to add in a vehicle must meet safety standards that were in effect at that time of manufacture, because the 1967 date is actually in reference to the Federal Motor Vehicle Safety Standard when it was adopted of that year. So making sure that these vehicles prioritize safety is of great concern for me. So adding their recommendation to add that change is definitely something I support. But to eliminate the whole amendment of what the bill is, which is one amendment, is to add in that 35 years, takes out the whole bill itself.
Okay.
Thank you.
Okay, thank you, Representative Iligan. So I appreciate those comments, and as I say, this is a work in progress, and I will support the effort to continue working on this. My recommendation is to pass out an HD1, defect the effective date to 6/30/3000, and incorporate one of the recommendations from the County of Hawaii Finance Department to add that the vehicle must meet safety standards that were in effect at the time of manufacture. With those recommendations, to pass out an HD1. Questions or concerns, members? Seeing none, Vice Chair for the vote.
Voting on House Bill 480 with amendments, noting presence of all members. Anyone wishing to vote with reservations or no? Seeing none, Chair, your recommendations are done.
Thank you. Moving on to House Bill 538. After reviewing the testimony and talking to the introducer of the bill and confirming with one of the testifiers that in fact the opposition was really to the first part of the bill, but the second part of the bill still merits further discussion. So I would like to continue work on this bill, move it forward for further discussion with an HD1 with the following changes. And I'll have to walk you through this because I'm not able to post a proposed HD1. So if you have the bill, I can walk you through it. On page 1, we're removing on line 2, such as reasonably maintaining their premises and refraining from using the premises for unlawful activities. I will retain, the legislature also finds that some properties are unwilling or unable to fulfill these basic obligations. Remove the rest of section 1, go into page 2, line 3. Accordingly, the purpose of the act is to remove first section, keep the second section, the second paragraph. Line 16, we would remove everything from line 16 down to the rest of the page. We would remove everything on page 3, and on top of page 4, remove line 1 and 2. We would retain on page 4, line 3, all the way to the end of the bill. So basically what I'm doing is removing part 1 of the bill and keeping part 2 of the bill. And part 2 of the bill is basically increasing penalties for unaddressed zoning violations and allowing for, if the fine increases to exceeding $5,000, then the notice of violation shall constitute a lien on the real property. And then again, allowing that county planning and permitting shall commence foreclosure proceedings if it's not addressed within 30 days after receiving the notice of the lien. This is a serious matter for a number of different neighborhoods. I would like to move forward HB number 538 with that HD1. I want to defect the effective date to 6/30/3000. Sorry for walking you through that, but that's my recommendation. Any questions or concerns? Seeing none, Vice Chair for the vote.
Voting on House Bill 538 with amendments, noting presence of all members. Anyone wishing to vote WR or no? Seeing none, Chair, your motion's adopted. I'm sorry.
With reservations.
Noting the reservations of Representative Kong, all others voting aye. Chair, your members adopt. Measures adopted.
Thank you. Next, moving on to House Bill 582. This is a very important measure, and I think we need to move forward with this. I will just recommend that we move forward with an HD1, defect the effective date to 6/30/3000, And I would like to ask the introducer of the bill to make some additional recommendations for amendments. Representative Ichiyama.
Thank you very much, Chair. Appreciate being able to work on this measure. So we're going to take, because of the comments and testimony, the concerns about some of the amendments on pages 4 and 5 of the bill. We're going to delete the change that would have said that a defendant has to be domiciled in the state. We're going to delete the requirement that there's a certification for each defendant. And we're also going to delete the language that the certification is electronically filed under seal. Thank you, Chair.
Thank you very much. With those recommendations, I would like to move out on HD1. Questions or concerns, members? Thank you, Representative Ichiyama. If there being no questions, Vice Chair for the vote.
Voting on House Bill 582 with amendments, everyone being present, anyone wishing to vote WR or no? Seeing none, Chair, your measure is adopted.
Thank you. On House Bill 586, this is one of the best practices that we were learning about at our recent info briefing from Amber Widgley from NCSL. And so even though there's some questions about how this is going to work, I want to move this forward. This is very important. I want to move forward in HD1, blank out appropriations, defect the effective date to 6/30/3000, and I would like also to insert something in here about email, so that would be another way of notifying people that they've got a court appearance. This is still a work in progress, but we've got to get a better handle on this and utilize some of these best practices. So that's what I would like to do on this one, HB 586, HD1, defect the effective date as well, if I didn't mention that already, 6/30/3000. Questions or concerns? Yeah, put the money in, yes, we would put into the committee report a request for appropriation of funds, but it would be a blank appropriation in the bill itself. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 586 with amendments, all members being present, anyone wishing to vote WR or no? Seeing none, Chair, your measure is adopted.
Thanks. HB 862, this is another measure that still is a work in progress. I do think that we need to move forward with this. I would ask the introducer to continue working on this as it moves forward, work with the judiciary. This really begs the question about the paroling authority setting minimum terms, but that's a different question that we'll have to address at another time. But in this regard, this bill allows for judicial review of orders fixing those minimum terms of imprisonment. My recommendation is pass out in HD1, defect the effective date to 6/30/3000, and move it on to finance and ask the introducer to continue working on this. Any questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 862 as amended, all members being present, anyone wishing to vote WR or no? Seeing none, Chair, your measure is adopted.
Thank you. House Bill 863, you've all been keenly aware of the need to address this whole issue. We almost went, we were getting calls to go into special session about this. This is a crisis. And so I do feel compelled we need to move forward with this. However, after working with the introducer and with my counterpart in the Senate, what I'd like to recommend is that we defer this bill and look forward to receiving the referral on Senate Bill 36, and when that Senate Bill 36 is referred to committee, that I would recommend that we schedule that for a hearing as soon as possible and move it forward. So recommendation on HB 863 is to defer. Okay, moving on. House Bill 864, excellent idea. I want to move this forward with an HD1 with some technical amendments, blank appropriation, but put in the committee report a request for $400,000 and defect the effective date to 6/30/3000. Comments or concerns? Representative Gannon.
Grateful for the testimony of the judiciary and their willingness to adopt some of the things that are happening in other communities where there's an overrepresentation of Pacific Islanders in the Pacific, in places like New Zealand, and the best practices of other communities that have a high representation of indigenous children in the justice system, similar to Hawaii, and look forward to seeing where this goes, should we get it done.
Thank you, Representative Gannon. Any other questions or concerns? If not, Vice Chair for the vote.
Voting on House Bill 864 with amendments, noting presence of all members. Anyone wishing to vote WR or no? Seeing none, chair measures adopted.
Thank you. House Bill 829, from what we hear from the judge, it sounds like, as Judge Hall said, they're already doing this, and this is very important to do, but the way that they're doing it fits in with the scheduling that they are mandated to follow. So my recommendation is to defer this measure. And the final measure on our agenda today, House Bill 1335, recognizing that we have another bill that's coming to us soon that addresses this. I would like to defer HB 1335, and then we'll take up HB 1336 when it comes to us. So my recommendation is to defer HB 1335. There be no further business before this committee today. We are adjourned.